Hear ye, hear ye. The Honorable Chief Justice and Justices of the Supreme Court of the State of Michigan. All persons having business with this honorable court are admonished to draw nigh, give their attention to the court is now sitting. God save the United States and the State of Michigan and this honorable court. On behalf of my colleagues, I'd like to welcome you all to the court's March case call. For those advocates who have not been here recently or not at all, I'd simply remind you that in calendar cases, the parties are allocated 30 minutes apiece, and for the arguments on application, you're allocated 15 minutes apiece. We provide you 5 minutes in the calendar cases, question free, and that is to permit you to give an exposition of the outcome determinative issues that you believe the court will persuade the court to decide in your client's favor. I encourage you not to spend a lot of time on the facts. I assure you, we have all read your briefs. So this is an opportunity for you to get right down to the important issues that you think should persuade the court to support your client. In the arguments on application, there are 2 minutes of question-free time. So with that, we'll call the first case, Wade versus McCadie.
Good morning. May it please the court. Beth Whitman appearing on behalf of the defendants. I would like to reserve 2 minutes of my time for rebuttal, and I would waive the free fire zone. The issue here is whether or not the
Counsel, good morning, and I appreciate the waiver, but I apologize for just jumping right in because I just want to ask a key kind of core issue. Looking at the definition of a medical bill, if your definition, explain to me what your definition of it would be. If a billing record is not, in fact, a medical bill, what would it be?
No, our position is that it's not a medical record.
I see.
Yes.
So what would it be then?
Well, a billing record, it may contain medical information. It's certainly going to contain the patient name and probably diagnostic codes, but it's not something that a physician would use to rely upon for diagnoses, for treatment, for...
But if it's not a medical record, again, what is it?
I think it's just something that's used for payment purposes to obtain insurance payment for the medical care that's provided.
So is it then covered by confidentiality? Like, is it open to the public? Is it analogous to my cable bill? Like, what would it, like, how would that fall under?
No, I mean, billing records are certainly covered under HIPAA, certainly. I mean, it still contains protected health information. So for purposes of HIPAA, it does contain that information, so it is protected. But that doesn't transform it into a medical record.
What is a medical? How do you define medical record?
Well, medical records, we cited to a couple definitions that we had at the time that the Notice of Intent statute was in effect. Most specifically, the definition that's in the Public Health Code.
Stop.
Yes.
Why is that relevant?
Because I think that is the...
Well, let me back up.
Sure.
Let's do this didactically. When the legislature uses common terms, medical record, how does the court go about supplying a definition?
Well, I think one of the things that they can look at is other definitions that are used. And there is a definition that was used at the time.
What case are you relying on for the court borrowing from an unrelated statute a definition to supply the meaning of a common term?
The other option would be to look at definitions.
I'm just trying to understand what your canon of construction is for undefined common terms used in a statute. What is the canon?
I don't have anything I can specifically cite to.
Does the court have a canon?
Pardon?
Does this court have a canon?
This court looks to the plain language of the statutes.
All right. If you're looking at the plain meaning, where do you go then to find that plain meaning?
This court also then indicates if there's nothing defined in the statute, then you can look at definitions, medical definition. Like I know the court has used medical dictionaries, regular dictionaries to determine that's
not going to an unrelated statute.
That is correct. That is correct.
All right. Well, what is giving medical records its plain meaning? What is it?
I think a medical record contains diagnostic information, the treatment modalities that were used, the history that's given by the patient.
Where are you drawing that definition?
I think that's probably the common definition that's used within any dictionary. I don't have that to cite to you right now, but I think that is the common.
You're here and this case turns on what a medical record is, and you don't have something to cite to us as the basis for our understanding of how to construe that term?
No, I understand that, but I don't think it necessarily turns on the definition of medical record. What it turns on is the plain language of the statute and whether we complied with our duty under MCL 600.2912B.
As to billing records, the question is whether they are, in fact, part of the medical record, correct?
But it's also whether or not they're related to the claim and they were in the control of the defendant. There's no dispute that they were in the control of the defendant. It's whether or not they're related to the claim.
There's no dispute as to whether they were in the control of the defendant?
I don't think so. I don't believe that there's any dispute that the billing records were in the control of the defendant. It's whether or not these fall within the definition of medical record and whether or not they are related to the claim at issue here. In the notice of intent.
Let me ask you a question. So even under the definition that you would like us to use, you point us to a different statute and you say that the definition of a medical record includes examinations performed, observations made, treatments provided, and in the case of a hospital, the purpose of hospitalization. Now, at oral argument in the Court of Appeals, defense counsel said that the billing records included diagnostic procedure codes, dates of testing, and charges for treatment. So why does that not fit within your own definition of medical record?
I think it does. And I think you're referencing the Medical Records Access Act,
This
definition?
Is, MCL 333.201751.
That's correct.
You
Yes.
told us
That's the one that
you
I
would like
was,
us to use.
That's correct, yes.
But, okay, so let's say we use your definition.
Mm-hmm.
The billing records here included diagnostic procedure codes and dates of testing.
Mm-hmm.
So why doesn't that fit within your definition, which is examinations performed, observations made, and treatments provided?
Because, again, billing records are not something that a doctor is going to have with them, even at the time that they're treating the patient.
Why does that
Why
matter?
does that matter?
Because these are not things that the doctor is going to rely upon in treating the patient.
Why is that relevant, given the definition you asserted we should follow? Whether the doctor relies on the billing record isn't necessarily whether it is, it has medical information related to treatment, right?
But it does not include tests and examinations performed, observations made, treatments provided.
If the healthcare provider is billing either the government or an insurance company for tests,
Mm-hmm.
that will be reflected as a billed item, will it not?
It may. I don't know the answer to that. It may just be a code.
If you don't know the answer to it, how can we make a determination that a billing record is or is not a medical record?
I think based upon the plain understanding of what a medical record is, a billing record doesn't even exist in the same portion. It's not included in a medical chart that a physician has.
But it doesn't have to be in a medical chart, does it, under the definition you've asserted?
But I still disagree that it is a medical record. It is not a medical record. It is a billing record. And even HIPAA makes a distinction between the two.
Here's the definition you urged on us from the Medical Records Access Act. Medical record means information, oral or recorded, in any form or medium that pertains to a patient's health care, medical history, diagnosis, prognosis, or medical condition that is maintained by a healthcare provider. Whether billed tests or medications that are being billed, those are, I think, information recorded in some form that pertains to the healthcare or medical history of that patient, correct?
It does say, however, in continuation, in the process of caring for the patient's health. That's not what billing codes or billing records are for. It's not to be used in the process of caring for the patient. It may be for insurance payment purposes, but it's not for purposes of caring for the patient's health. And it also references, and granted, I made this argument that the Medical Records Access Act did go into effect 10 years after the Notice of Intent statute and the Affidavit of Merit statute went into effect.
So they're really not even in prior material.
That's correct. That's why I looked at the definition of medical records that was set forth in the Public Health Code in 333.20175. But even if you look at the Medical Records Access Act, there's the provision that Your Honor just cited. There's also the definition of health care above that means any care, service, or procedure provided by a health care provider or health facility to diagnose, treat, or maintain a patient's physical condition or that affects the structure or a function of the human body.
So tests that I bill for are disqualified from the understanding that these were things done I did in pursuance of the patient's health?
The records that may contain that information of what tests were done, the outcome of those tests, all of that may be that would be in the medical record. Just because some of that information is then transferred to a billing record for payment purposes does not transform those records into medical records. They're completely separate. But I want to go back to the other issue. There was no dispute that the only two things that were not allowed, that plaintiff was not allowed access to during the notice period were the billing records as well as the records, the lab reports between 1979 and 1992.
Those, you claim, were unavailable because they had been destroyed.
That's correct.
Unlike the billing records, which you did today concede you had, but you just didn't produce because
That's
you didn't
correct.
think they fell within the...
That's correct.
So
But
billing records cannot be treated in the same way that the lab reports are. They do not qualify for the same treatment.
in the control of the defendants. That's correct. But for both portions of that, both the billing records as well as the laboratory reports between 1979 and 1992, there's still the duty. The duty is only triggered to allow access to medical records that are related to the claim. So it's our position, even...
Are you contending that the defendants get to determine in a mid-mal case what's related?
That is correct. And the Court of Appeals even recognized that fact. They said, I know they said that we were under an obligation to give all records, give complete records, and we couldn't pick and choose between the two. But then in the footnote 2 that they have at the end of the opinion, they absolutely admit that we can do that. They gave the example of we don't have to provide medical records, I think, from a unrelated birth that occurred 5 years prior. So they recognize the fact that this gives us the opportunity or the ability to pick and choose what records are going to be provided.
But didn't the Court of Appeals also, in that same opinion, indicate that their concern was that this would lead to gamesmanship? And I'm just wondering if you could comment on that.
Well, I disagree that it was gamesmanship under the circumstances here.
Well, I'm not saying it was. I'm just saying that you're citing the Court of Appeals opinion, so I'm
Sure.
kind of following up in terms of that citation
Right.
with the fact that they made a huge emphasis on the issue of gamesmanship.
Mm-hmm. I think, if you use their hypothetical of the 5-year prior unrelated birth, what if the plaintiff under those circumstances said, okay, you know what, I think that say it was a knee surgery that occurred 5 years later, and they didn't give me the medical records from a delivery that occurred 5 years prior. But I think that's when the knee problems started to occur. That's when they were first documented. I think under those circumstances, anything that you might deem to be irrelevant could still be deemed relevant by another party at some other time.
Don't you bear the burden, the risk, that if you choose wrong, you trigger the delayed filing?
I think the plaintiff runs that risk. I think
No, if the defendant makes a determination about what is or isn't relevant, and that turns out to be wrong, doesn't that in fact trigger the delayed filing requirement?
that could, absolutely. But I think the opposite is true, too. If plaintiff makes a unilateral decision that they were not allowed access to all medical records related to the claim in the defendant's control, and they don't file the affidavit, and they file it within that 91 days, then I think they run the risk.
Somebody gets to make a determination about relevance, and it isn't just the defendant.
That's correct. It's not the defendant. I don't think it's the plaintiff either. I think the trial court judge has to be involved in those circumstances. And I think here there was, plaintiffs can still protect themselves. There's sufficient time in between in this case at least, between the filing of the complaint and when the statute of limitations expired. They could have requested.
If you want to reserve any time now.
Okay, very good. Thank you.
Thomas Miller on behalf of the respondent, Your Honor. Chief Justice Young, in answer to your question about definitions, the court certainly can look to current statutes defining those terms, and 2626-3A1 does define it as you read it a few moments ago. And medical billing certainly fit in within that definition, within the definition of medical records. We can talk about hypotheticals about knee injuries or births or things like that. In this particular case, it's plaintiff's contention that Mr. Wade suffered from hypertension for a long period of time and it went untreated. And as a result of that hypertension, it became so severe that he lost all kidney function. This is not, when you visit a doctor's office, the first thing they do is do your blood pressure check. The laboratory records were not the records that were destroyed. It was the clinical observations and the blood pressure readings and things of that nature that were destroyed. The medical records then become very, very important because that's the only thing that gives you any idea of what the physician did other than the limited lab results. And there were almost no lab results that were relevant to the issues in this case. And yet, it's very likely that he was suffering from blood pressure for a long period of time, elevated blood pressure for a long period of time. So it is important to know what the billing codes were. What were the diagnostic codes? Was there a diagnostic code about pending renal failure? Defendants argue very strongly that the language of 2912B5 need to be interpreted strictly based upon the words, but yet the first three words of the statute says within 56 days these records are to be, the access is to be permitted. There is no dispute in this case that defendants provided no access within 56 days. They are arguing that by simply having provided some records at some earlier time.
Can you provide access to records that no longer exist?
Well, obviously no, Your Honor.
Oh, I'm sorry?
Obviously no.
Okay.
But what I'm saying is they didn't produce even the ones they had in their possession within 56 days.
Which documents were those?
The pages of the records that had not been destroyed, and the billing records.
Okay, billing records on one side. You're saying they had medical records that they did not supply within the 56 days.
Correct.
How do we know that?
Even if they, in other words, they argue that the legislature could, in one of their arguments about whether you have to produce all records or those that are related, they said.
I'm trying to figure out, I'm not as familiar with the record as you are.
Okay.
So how do we know that they had records, medical records, not the billing records, that they did not produce?
Within 56 days of receipt of the notice of intent, they provided 0 pages of records. Okay. They're arguing that by having provided 134 pages in response to a letter requesting records at an earlier date.
That's under the Medical Records Access Act.
Right.
Okay.
But once, okay, sure, I'm sorry.
Justice Martin has a question.
No, Mr. Miller, I'd just like to know what rule would you like to emerge from this case with regard to billing records? We're going to have future cases that deal with somewhat the same issue involved here. Is it your view that all billing records are medical records, or all billing records that contain either diagnostic codes or information concerning the services or some kind of plus information constitute the kind of billing records that comprise medical records that do need to be turned over in toto within a certain period of time? What is the rule that should emerge from this case in your view?
What I would suggest, Your Honors, is that you determine that billing records are medical records.
All billing records.
Then, now you fall to the qualifier that appears in the statute, and where you take that about related. In other words, once you put it into the basket with medical records, then the qualifying language of the statute saying that they have to produce records relating.
But if the billing record, I just want to understand again what the rule is. If the billing record says nothing other than $65 and you're able to connect that sum to a particular procedure, is that a medical record?
Yes, and attached to my brief was how the University of Michigan treats it.
I'm not asking.
I'm
a
saying
general question.
I think the court should recognize that billing records are part of the medical records.
Why?
Why? For a number of reasons. Because they provide access, ICD, International Classification of Disease, they give you the dates the patient was at the clinic, so you know how many times the patient went there. Then the patient can say, each time I went there, my blood pressure was checked. He didn't get to renal failure without a lot of elevated hypertensive caused renal failure. So the actual date of visits is important, because if you go in for something related to your arm, they're still going to check your blood pressure. So Justice Markman, knowing the exact dates he was there is important, because a lot of times, real life experience, clinical records are missing, but on the billing records there's a date showing that the patient was there, and then you can ask the question, where is the clinical record? So it's very important.
Your argument makes sense, but is that not something that you ferret out through discovery, as opposed to really, is this a medical record that must be produced that might trigger the 91-day window for you?
It's critical not only for me to know how long his blood pressure was checked. If his blood pressure was checked and it was elevated and they didn't do the appropriate testing.
That you can deduce that blood pressure might have been checked at a visit doesn't turn it into a medical record.
Well, but in this particular, let me talk about this particular case. Not only that, but it would determine whether or not I have a cause of action.
Problem, sir, it's not just about your case.
No, I understand, but
But this, we're trying to figure out, not for this case, but all the cases that come after,
right,
what a medical record is, and therefore what the respective obligations are of the defendants and plaintiffs. And you start out by telling us that despite this court's fairly straightforward and consistent canon of construction for common terms but undefined ones in legislation, we typically look to the plain meaning. You suggest that we look to an unrelated statute. Isn't that what that's the start of what you said?
No, Your Honor asked, where are you permitted to look? And I simply said, yes, you look to the common usage.
No, you said we look to the Medical Records Act.
What I'm saying is, I agree you look to common usage, but I'm simply saying if you want to go beyond it, all records incident to the care, just as, even though the common usage is, if I want to go in and get my medical record, I'm going to get billing records.
Are you?
Yes. If I say I want records, I'm entitled to the billing.
What you're entitled to and what everybody understands as a medical record might be two different things. I don't think I've ever gotten a billing record when I've requested my medical records from any provider.
I would simply say, in response to your specific question, I think the common usage of medical records includes billing statements, because
So
it provides a lot of the information.
On the definition, we should cite you for the proposition.
This entire endeavor has been bogged down by both sides failing to recognize that this court has said, in the Grimes case, I think it was 2008, that looking to another statute for a definition is a perilous endeavor that should be avoided by the courts at all costs. And so you're both looking at other statutes, and that hasn't helped us one bit. We really need to look at the common usage of the terms, and especially these statutes that were enacted after, right? It's to be avoided at all costs at all times is our jurisprudence. That's what we say. But even more so when the definition comes into play years after the original act was passed. And so what we really need to focus on is, what does it mean? What is a medical record? And why should a billing record be a medical record under this act? It's actually rather simple.
Justice Zara, I would simply say that we're not looking at another act for this definition. The act that isn't in any way related to the act we're looking at. The act we're looking to is called the Medical Records Access Act.
It is not a part of the Med-Mal
If you want to go down that road after I told you what I just told you about the Grimes case, go ahead.
No, what I'm saying is...
That act came into play 10 years after the Med-Mal reform statutes.
But it was amended to expand the definition of medical records in 2004.
Is there something you don't understand about what the two of us just said?
Other than say, Your Honor, that
we do not historically, at least our jurisprudence says, and Grimes is one example, we don't look to unrelated statutes to define a common term.
I'm simply saying, as a supplement to common usage, if the court, frequently when you ask for oral arguments on a application, you will say particular attention to the definition of medical records. I would simply say, or something like that. And that wasn't done, so I apologize that I can't cite where the definition is, other than to cite what the University of Michigan defines it as.
Okay, so
which
now
goes to common usage.
We're using your definition, we're using University of Michigan's definition.
I'm simply saying they include billing with medical records, as part of medical records.
As much respect as I have for the University of Michigan, they aren't courts. They don't construe statutes. We do. And we expected help from the parties' advocates to help us understand that enterprise.
I appreciate that, and
Apparently.
I'm not that well versed on the procedural rules with this court as to what any supplemental briefs might be asked for, or...
You came here unprepared to tell us how to construe this term?
No, I didn't. I said that I don't have a definition to cite. Okay. I acknowledge that, Your Honor.
Tell me about the records that were produced. They were produced under the Medical Records Access Act, correct?
Correct.
They are exactly the records that the defendant says they have that would be responsive to the Med-Mal Act request.
Well, that's...
Leaving aside the billing records.
Well,
Is that right?
And also, the Medical Access Act, which does apply to your question about the earlier request.
Okay. Wait a minute. I'm just trying to understand what we're talking about. Apart from the billing records, all of the records produced in response to your client's request for documents of the Medical Records Access Act are the same ones that would have been responsive to the Med-Mal request, correct?
Based upon their assertions, yes.
What is missing are those documents, those medical records, leaving aside the billing records, that they had destroyed.
Less those, yes.
Okay. So your argument is even though they produced the documents in response to another statute, the fact that they didn't produce them again under the Med-Mal request constitutes a violation of the Med-Mal disclosure requirements?
But under the Medical Access Act, they also have the responsibility to inform the requesting party whether any records no longer exist or have been lost.
Yeah, that's a violation.
And they didn't do that.
That's a violation of the
Right.
Medical Access Act. There is no such requirement under the Med-Mal provision.
I can see, but Your Honor was asking me about if they provided records in compliance with the medical access records earlier, would it be the same that they had to produce?
No. I'm trying to figure out whether there was a violation of the disclosure requirements of the Med-Mal Act. I thought you were saying to me there is, because they didn't provide the very same records that they supplied to us, leaving the billing records aside, under our earlier request for under the Medical Records Act when we requested them in the Med-Mal Act. Is that what you argued? I don't care whether there's a violation of the Medical Records Act. I'm only concerned about whether the records that qualify under the Med-Mal were actually supplied.
Yes.
Okay.
Again, not talking about billing records.
Okay, that's right. Thank you.
All right, there is no provision about failure to or inform the party that they've lost the records or destroyed them.
Under the Med-Mal Act.
Right.
Correct. Thank you.
Thank you, Your Honors.
Just very briefly, I just wanted to make 2 points. It's our position that we have complied with the statute, with the plain language of the statute that requires that we allow access to all medical records related to the claims that are within our control. The plaintiff had access to those records during the notice of intent period because we had provided those records prior to the notice of intent being sent. So they were able to use those records in order to compose a notice of intent, as well as to file a complaint, and ultimately those are the same records that they use to file an affidavit of merit.
Is there any reason why your client didn't comply with the Medical Records Access Act and respond to the previous request by indicating that the records had been disposed of?
I don't have any information as to why that was not done, but I would submit that
Doesn't that sort of create an information imbalance in this process? Because that's something that would only be within your client's knowledge and control, right?
But as Justice Young indicated, there's nothing in either 2912B5 or 2912D3 that requires that we comply with the Medical Records Access Act, or that a failure to comply with the Medical Records Access Act is going to afford the plaintiff an additional 91 days to file the affidavit of merit. They are two separate statutes. If the legislature intended for a failure to comply with the Medical Records Access Act would afford plaintiff the additional time, or wanted the defendants to be subject to the duties of the Medical Records Access Act, it could have done so, but it didn't.
Going back to the core issue of what a medical record is, when you look up medical as part of the compound term medical record, I don't think we worry over much about what record means, but medical means, when you look it up in a dictionary, Merriam-Webster's, for example, means of or pertaining to the study or practice of medicine. The American Heritage Dictionary says that it's pertaining to or indicating the state of one's health. Those are broad enough to encompass billing records, aren't they?
I still don't think that they do. It's still talking about the diagnosis and the treatment. It's related to the patient's health.
If the codes reflect the treatment, why isn't that a history of the medical services provided?
Because the physician is never going to use that information that's in a separate record that's taken from the medical record in order to provide care and treatment and
But
to
it's
care for the
indicating the
patient.
state of health, doesn't it not?
But it's taken from the actual medical
care where
record.
it's taken
I know,
from.
but I don't think that taking information from a medical record transforms something else into a
Well, if
medical
you take
record.
information from the chart and put it in a nursing chart, it doesn't transform its character. The hospitals and providers have all kinds of charting.
That's correct. And there's nursing notes and physician notes. All of that relates, though, to the health in the treatment of the patient. They're not going to use the billing records for that purpose.
Thank you.
Okay, thank you. So for those reasons, we would ask that the Court of
Ms.
Appeals
Whitman, I
decision.
have one final
Oh,
question.
sure, please.
If all that stands between me getting access to certain records, say tax records, in the possession of my accountant, is that I must call the accountant and get those records, can it be said that I'm not effectively in control of those records?
You, I guess the taxi
Me, the
or.
person to whom those tax records pertain.
Yeah.
Right.
That's a good point. So, so
I thought it was too, actually.
So the argument being that the plaintiff is always in control of those records because they are
Well,
their
you
records.
presumably had some kind of billing service, and they were in the possession of records that were not in your possession, but would it be an insuperable task to call them up and ask them to provide you with those records?
For the facility to request those records, or for the
Yes.
patient to request those records?
For the doctor or the hospital?
I'm sure they could. I don't think, again.
So would they not effectively be, as I say again, would they not effectively be in your possession if that is, or in your control,
In our
rather,
control.
if that's the only barrier to you
I
having
agree,
them?
and I think I conceded that there was no issue with respect to the control of the medical
The
records.
defendants control these billings.
That's correct. Yes, the billing records, I'm sorry.
I
But-
thought you repeated that concern a few minutes ago.
Yeah, but if nothing else, the Court of Appeals decision was just overly broad in requiring that we provide all medical records, complete medical records, and that's not what the statute
Thank you.
says. Thank you.
The case is submitted.